Yes, this is James with Premier Legal Services. I was just providing a little informative video on what to do if you are sued for old credit card debt. In our practice, we've noticed an uptick in consumer lawsuits, specifically for old credit card debt, voluntary repossessions, student loans, things of that nature. And we just wanted to outline exactly what to do because we found that 90% of the time, most people actually ignore the lawsuit. They don't take it seriously. And I'm going to explain why that's a mistake. What you'll notice is, one of the first things you'll notice if you're being sued by an old credit card debt, for an old credit card debt, by a creditor, is you may start to receive attorney letters in the mail, outlining exactly, stating that you're being sued. And with some people, it causes some suspicion. They think that it's not real. And then later on, once they're actually served with an actual petition, then it becomes more serious for them. Okay. It's okay to accept the petition if you're being served. Typically, these creditors, after they file the lawsuit at the county courthouse, the courthouse will assign a process server, and on occasion, maybe a marshal or a deputy, to go out and serve you with the actual petition. It does not mean that you're under arrest. It's not a criminal offense. It's a civil case. So you can go ahead and accept it. But once you accept it, you do have a time frame in order to file a response. Otherwise, the creditor can move for a default judgment. If you notice in the picture on the screen, 90% of people that are served do not answer the lawsuit. Basically, once you're sued, you have typically between 14 and 20 days to file an answer to the court. If you do it personally, you have to go down to the courthouse, fill out the form, and just file it. Typically, you can get away with just a general denial, which would allow for you to have an answer on file, and then the court can go ahead and set a court date in the future for the creditor to make their case against you. Unfortunately, most people do not take these type of lawsuits seriously, and I'll explain later why that is a major mistake. But at the very least, once you're served, go ahead, go down to the courthouse, file the written answer, and wait for the court date to arrive. It gives you a lot more flexibility than if you just let it lapse due to negligence and you wind up with a default judgment. Because once it becomes a default judgment, some nasty things can happen from there. If you notice in the image, again, 90% do not answer the lawsuit. Why you should respond to the lawsuit is, number one, preventing a default judgment. That's where the creditor can go to the court and basically state, hey, we filed a lawsuit against Johnny. He was served with the petition. He had an opportunity to look it over and read it and file an answer to the court, but he neglected to do so. So we want to go ahead and move for a default judgment, which would legally stick Johnny with this debt. Okay, and number two, it makes the creditor prove that the debt is in fact legitimate. A lot of times, the creditors will file lawsuits against you. In fact, anyone can file a lawsuit against you that it's not a legitimate claim, or they can't back it up in court. But they're banking on the fact, due to past history of people's behavior, 90%, that you're not going to answer it. So they're actually playing the odds that they can get away with sticking with a debt without having to prove it. Make them do some work. Go ahead and allow for them to prove it in court. And number three is to protect your assets. And let me explain what that means. If they file for a default judgment, they can then pursue post-judgment collections, meaning that they can go ahead and file a writ of garnishment, have a judge sign off on it, and freeze any bank account, checking or savings, linked to your Social Security number. They will not give you advance warning. The way most people find out is when they swipe their ATM card, the debit card, and they get a decline. It can cause a major financial inconvenience, and trust me, you do not want to have that happen. So go ahead and file the answer. I will explain in a future video exactly how to do that, but I just wanted to give you an update as to why it makes sense to file an answer and not just let the creditors get away with cheaply getting a judgment against you and then risking them freezing your bank account.